Thank you, dear colleague. I would like just to say a few words in English. Thank you, dear colleagues from Romania, from Slovenia, and as I saw, colleagues from the United Kingdom and United States of America. Thank you for coming in our republic and to participate in this very important conference that's held here in Banja Luka in our government.
U našoj zgradi vlade. Now I will continue in Serbian since I wrote this paper in Serbian. The topic, as you may have heard in English, the state and church right, and why I'm saying the Republic of Srpska in this title, because churches are at the same level in state level in Bosnia and Herzegovina, but given the days of yesterday and the last my paper should become obsolete, I will change this domain from B and H into the Republic of Srpska state ownership. Namely, I will say now that there are three models, and total separation, cooperational separation, or state-church system are models are not met in practice so often, and we see a lot of variation of all three models. So, for example, in France, when we talk about this system of apolitical and total exclusion, we see that there are certain overlappings between church and state. Unfortunately, this is more prevalent in new churches than in the traditional churches recognized in 1901 in France. First of all, Roman Catholic, Protestant, and the Jewish community. While on the other hand, in Greece, we have a situation that even though we often mention it as a study book example of state religion and relation in where the state and church have closest relations, it is Orthodox Church. There are certain moments where the state and church are diametrically opposed. On the other hand, the Republic of Srpska builds its relations on the basis of certain constitutional texts, international agreements, and one law. Namely, there are two constitutions, Dayton Constitution Annex 4, which only stipulates that religious freedom is one of the basic human rights that shall be respected in B and H. The other constitution is the Constitution of the Republic of Srpska, which is far more important for us, namely in Article 28 of the Republic of Srpska and its paragraph 3, it is said that Serbian Orthodox Church is the church for all Serbian people and other Orthodox people. Thus, Serbian Orthodox Church is placed at some constitutionally privileged position in comparison to other changes. There are historical reasons, because the genesis of the Republic of Srpska was related to the expression of Serbian people for freedom and creation of a state in the 90s. So the Republic of Srpska is older than Bosnia and Herzegovina, hence the Serbian Orthodox Church does have this constitutional privilege. And on the other hand, there are theologians here, and they must say there is canonical unity, because the original canonical unity stretches back into the B and H territory. So any Orthodox believer, when they come to this canonical jurisdiction, they are under the territorial jurisdiction of Serbian Orthodox Church. So it is very interesting that our constitution also respects these canonical rights, and we can say that it is rather rare. For example, I did not manage to find any such constitution elsewhere. On the other hand, we had paragraph 4 of the same article that was deleted through amendments, and this paragraph 4 envisaged that the Republic of Srpska will provide financial support to Serbian Orthodox Church, but the intervention of the High Representative, this paragraph was deleted, but as such it is incorporated in international agreements that had been signed between the Serbian Orthodox Church and Bosnia and Herzegovina, because financial support to churches is something that the state does on regular annual basis, and there is special budgetary item for all churches and religious communities, whether at the level of BNDH or the RS. On the other hand, we have the basic contract between Serbian Orthodox Church and Bosnia and Herzegovina, signed in 2007, ratified in 2008. It is important to know its legal nature. It is an international agreement par excellence because it was adopted and envisaged during the creation of the country and later ratified by the Parliament of BNDH through the complicated procedure prescribed by our law. As such, it supersedes other laws and it opens up an array of questions regarding relations between the Church and the state, in the general sense of the word. And I will say what relations they actually are. There are 3 documents of importance, such as the law on religious liberties, and that is something that many of us have talked a lot, and probably my colleague Dragan Davidic talked about it as well. But I would like to mention one historical fact. This law was published in the official gazette. It goes back to 2004, and we had this law 2 years before Serbia. They adopted their law in 2006. So these modern solutions that we had, that we incorporated in our constitution, like Professor Lalic said, you must start from the sociological moment. There are 3 confessions or more religious denominations, and the way our legislator managed to do it in 2004 is worthy of attention because this opens up a big space for cooperation. This means that the state and the church would go about their business, which are inherent to both of these institutions, but they cooperate in the issues of importance for the society. And this is a bit personal remarks. I think there are very few states that have cooperation between state and church, or those that insist on total separation of church and state, because that means dying of any educational enlightenment or any social advancement, because there are people who definitely gravitate towards their churches and religious communities who demand from the state to manifest a certain system of values, something that their families can appreciate. So, total exclusion between state and religion turned out to be a fertile ground for big conflicts and lack of understanding. For example, in France, you have religious classes issue. Maybe my colleague Lukic knows more about it, namely lack of regulation of science in France led to the situation where Islamic community organized religious classes without the state, because in the norms it is not forbidden, it's just that the state does not regulate it. So you see how much it means when the legislator is silent, then when they speak explicitly. So the basis was created that Islamic science was being implemented in the territory of France without state having having any control over it. And that, in my opinion, is very wrong. The relations between the state and the church in modern days should rely on mutual understanding and cooperation. So this ample field of social norms needs to be regulated in norms. The second important law or act is the instruction on the implementation of the law from 2019, because 15 years after the implementation of this law, we understood and realized that maybe some things should be better explained.
And then we issued an instruction on a number of pages, which addresses a number of dilemmas only. Many have remained. So the most contentious issue, and the most debated issue in the area of church law is the registration of churches and religious communities. We know this very well. We have colleagues who are jurists who know this issue very well. In the legal regime of EU states, churches and religious communities are traditional or newly registered. Traditional, that are recognized throughout history, who are even older than certain states. On the other hand, there are newly registered religious communities because under Article 9(1) of the European Convention on Human Rights, you cannot, in the context of Article 11, prohibit the right to association of persons to new religious communities or churches. But there is this divide between substantive and a procedural aspect. Yes, there is a substantive right. Yes, you are entitled to association and you may be registered, but how? That's why this registration procedure has turned out to be vital. So in the process of registration of new religious communities, you need to abide by certain principles, including the views of the society. In all conservative societies that have a history of their statehood and legal order cannot just like that accept the registration of all sorts of religious groups, as we call them in everyday speech, that emerge. Recently we had a case, I don't think you mentioned this, but I also deal with the relationships between the church and the state. So we had a group recently that was characterized by the Serb Orthodox Church as a heretic group. So did you hear about that? Okay, you know, when they use the coat of arms and all the insignia of the Serbian Orthodox Church. So what I'm saying, they're all registered. They are not in the single register of churches and religious communities. So without a legal status, you may not enjoy the rights and obligations, because that would mean that you're operating in a criminal zone, and the state repression will be deployed. So this actually, in this case, amounted to the abuse of name, identification, etc. Why am I saying this? Because the process of registration of churches and religious communities is one of the major or most important issues of the church law right, because depending on the flexibility of conditions and requirements, we'll either see a flooding of new religious communities, just in some Western states, or we'll simply freeze our system of registration, and then we'll be under the attack of the European Court of Human Rights and, Western parties, dictating how we should implement the right to association. So I'll speak about a number of important issues that concern the relationship between the Irish government and churches. I don't think we have regulated it all. Very often we take the de facto situation as such. For example, customary issues. But this is not quite good, not for the church because of the issues concerning legal certainty, and not for the government because the government needs to regulate certain relations. First of all, the right of publicity, the forum externum, the expression of the right or freedom to faith in public space. We do know that this right of publicity is expressed through rites, church rituals in public spaces, not just in the designated buildings, then also religious classes. And my colleague Lukic can speak about that better. Establishment of educational institutions by churches and religious communities. So what is the way in which a church should set up a school, for example? What standards should be in place? What's the discrepancy or disparity between the institutions established by the government and those established by the church or religious community? For example, if an education has a name that includes the name of a religious community, for example, we have a Catholic school center, or the Roman Catholic high comprehensive grammar school, right? So what does it mean for the status of that school? This needs to be regulated not by secondary legislation, but by primary legislation, because the treatment and the level of normative responsibility is not. It depends very much on whether it is regulated by primary or secondary legislation, because if you breach primary legislation, the breach or violation may amount to a criminal offense and implies criminal liability. But if you breach secondary legislation, you may bypass it from time to time. On the other hand, there is the so-called caritative action, which needs to be reflected in laws. There are institutional assets and property that's referred to in the agreement, the foundational agreement between Bosnia and Herzegovina and religious community. It's never happened in early at the turn of this century. The Republic of Srpska tried to sort this out with a restitution law, but Wolfgang Petric, the then High Representative, set the law aside, saying that it cannot be just the Republic of Srpska do it without the Federation, because it would mean that the Republic of Srpska actually would be a good guy doing the good thing, and the Federation would be seen as a bad guy. So 20 years later, we are still quite willing and prepared to implement the restitution law, but the Federation simply refuses to do so.
Pastoral service, which is regulated in our prisons, hospitals, orphanages, old age homes, army, police, and we have the priest Dragan Grujic who operates within the army, and the solutions are rather solid. There are two laws, one regulating the army and the operation of religious priests, while in the bylaws within the Ministry of Defense they have other rule books and so on. While they're functioning in old age homes, in orphanages, they also need to have a certain type of relation with church, and they should have their pastoral service. This should be regulated through the law on health service or another rule book. As for tax policy, my dear colleague did mention it. Taxes are, shall I say, always important and a question that can be debated, and there are many similar solutions. I was listening about Romania and Bosnia and Herzegovina in terms of exemptions and how these material and intangible assets that are used for worship, which are excluded from the taxation, and I think that there are a lot of good solutions. In construction too, you may know that the Ministry of Construction cannot issue license for building our place of worship unless there is a blessing of a priest and archbishop. So this assumes a certain prior consent without which you cannot make the ultimate license. And that I discussed often with my colleagues who say, and they say it is a new angle of viewing things. Right, the international contract is directly applied here, but it needs to be regulated, because what happens when you have some monuments or monasteries built, for example, Manastir Gomionica, that has existed here for several centuries, belongs to Serbian Orthodox Church, which as such is immobile cultural heritage of the Republic of Srpska. But on the other hand, it is a par excellence asset, immovable asset, run by Serbian Orthodox Church. So it is very important to juxtapose the law on cultural heritage that protects this church with the regulations that church can have in line with the international agreements. So the state can protect something, but how far-reaching is that protection? Because the state, the country needs to be asked about certain things: conservation, restoration, whether you can bring certain church mobiliaria into the monastery, can you lean it onto the wall, and so on. So these are some details, but these are filigrane details. They do have an impact onto the whole thing. You cannot exclude this as a trifle thing that shouldn't be discussed, because in practice it can be important. Recently we had archaeological digging next to Monastery Paprače, and the Institute for Protection of Cultural Heritage has its view how it should be done. And on the other hand, you have monastery management who say, well, you shouldn't damage the monastery if you are doing the digging. So that is where I think there should be additional regulations, again in line with international contracts. And I will finish with a nice part, and that is family legislation, which in this basic contract between Serbian Orthodox Church and Bosnia is especially mentioned, and that means that the Republic of Srpska has an obligation. Even though family legislation is liable to change, it must not deviate from its obligations assumed in the international agreement. And that means that the population in the Republic of Srpska, almost 90% of them are Orthodox believers. They must bear in mind that when introducing novelties in legislation, they should not undermine the value systems that this big population cherishes and which they practice through their faith. And we recently had a big discussion on that topic in the Republic of Srpska, because there were certain talks about the law on femicide and protection of women, where they try to change family legislation contrary to the laws and contrary to the contract between the church and the state. I just touched upon several topics that I will analyze further in my paper, and this will be my modest contribution to the development of church and state right in B&H. Thank you for your attention and patience.